We believe we've got very good prospects of success. We've done applications seeking the leave of the High Court for it to permit us to appeal against the decision of the court on both the issue of conviction and also on the issue of sentence. So the applications are now pending for the court and we'll have to hear from the court. But we believe we've got very good high prospects of succeeding to convince the court that it must permit our clients to challenge the decision of the High Court in the Supreme Court. Number of grounds of appeal, some which are stated in the notice of appeal, but basically our clients are challenging that the court made some errors in finding them criminally liable for an offense which they protest that they did not do and they are innocent of. And that the court made a number of errors, some of which includes the issue of whether or not the court was correct to convict them on a charge that our clients allege was not part of the charge sheet, relating particularly to the issue of whether or not they did corporate theft, corporate identity theft or not. It provides for us to also go to the Supreme Court and appeal against the refusal to grant leave to appeal against that decision. So if they are not successful, depending on the instructions that we have from our clients, it is still an avenue that is open, that they can take the matter up on appeal against the refusal of the leave. But we are hoping that we will not get to that extent.
I'll go with what my learned friend has said. The only thing I can add is that given the importance of this matter, ordinarily one would grant leave to appeal. Of course, there are a number of factors that are taken into account, but you also take into account the importance of the matter. I mean, you have been tried by the High Court. The general principle in our Constitution, if you read Section 70, subsection 5 of our Constitution, it contemplates that ordinarily two courts must be involved. You have the court that convicts, tries and convicts, then a person must be given a chance to approach a higher court. And as things currently stand, if you are convicted, tried and convicted by the magistrate court, you have an automatic right to appeal to the High Court. There is no requirement that you apply for leave. But this requirement that you apply for leave still exists for those who are tried and convicted by the High Court. There is no automatic right to go to the Supreme Court. But because of that difference, generally we would expect the courts, before the law is changed, to lean in favor of allowing a person to be heard by at least a second court. That's why we are very confident that the judge will certainly take that into account and then grant leave to appeal. Our clients are not unhappy about that. We would expect that in the shortest possible time, the judge will tender his order. It's likely to be an order which simply says the leave is granted or leave is denied. So far we think it's positive that is happening.
For now, I think our minds are settled on the leave to appeal, which I think my colleagues have really articulated well. I'll just add in on what Mr. Madhuku said. That's why there's a lot of media attention over this case. I mean, it's a very important case, and it has produced some very novel, new issues that we need the Supreme Court to tonight. But I think the public interest deserves that this case be brought to the highest court in the land, which is the Supreme Court, so that issues can really be determined. I think even the media and the public itself, they also want to know whether or not our clients really stand a chance in the Supreme Court. And we believe that this is a deserving case, simply because on national interest and other issues that my colleagues have said, it's one case that deserves for the Supreme Court to hear.